Hello, my name is Cesar Pereira. I'm the chair of the CIArb Brazil branch, and I welcome all of you. Good morning, good afternoon, good evening, wherever you are. Um, it is a pleasure and an honor to have this joint webinar today with the CIArb European branch and with BRICS, the study group on the BRICS countries connected with the University of São Paulo to discuss international arbitration in the BRICS countries. And as you have seen, this is our episode 1. This is the first of a series of episodes of webinars that we will have. And we are very proud to start this series with our friends from Russia. Um, just to give you some context, the CIArb, the Chartered Institute of Arbitrators, is an organization that was created in London in 1915. It's over 100 years by now. Now it has more than 20,000 members across the world in more than 130 jurisdictions. It has 41 national branches or regional branches, like the Brazil branch and the European branch. Its mission or missions is to develop and disseminate knowledge on alternative dispute resolution, to establish and enforce ethical standards, and to develop best practices to um, 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 uh, publicize guidelines, protocols for practitioners and arbitrators in dispute resolution. And in a way, maybe the mission that is most connected with us today, to offer a global networking platform. And we are today taking advantage of that platform. And I think very uh, strongly our friend José Nantala, who is an associate of the CIArb Brazil branch, for this idea that evolved into what we are living here today, and which is taking advantage of this global networking platform, of the possibility of technology to be together today with um, uh, distinguished scholars from Russia, distinguished scholars from Brazil, who can be together and discuss very important practical issues with the ease of technology, with the sustainability of technology, with the low cost that we can have now with only this not small loss, which is missing the opportunity of being actually together and sharing some the personal moments that we are unfortunately not able to live through technology to a platform like this. But it's very good and it's very stimulating that we are able to be together with such a remarkable lineup of speakers today. We're very fortunate also to have with us, and I believe this shows the practical importance of this initiative, to have with us the Russian Federation trade representative in Brazil, Mr. Victor Sheremetka. And Mr. Sheremetka has been in Brazil for several years now. He comes from the private sector, actually, and has been connected in several different capacities to international trade. And before we move on with the program, I would like to invite Mr. Sheremetka to say a few words about the importance of bilateral trade between Russia and Brazil as some type of a backdrop for the discussions that we will have today on dispute resolution. So without taking any more of our distinguished speakers' time, I would like to thank you all, thank our panelists, our discussants, thank especially José Nantala for this initiative, thank our partners, CIArb European branch and BRICS. Invite all of you to follow CIArb Brazil, CIArb Europe, CIArb HQ in London through LinkedIn, through Instagram, through all the platforms that are available today, so that you are always in tune with our initiatives. And lastly, I would like to turn the floor then to Mr. Victor Scheremetker for his talk. Thank you so much. And Victor, the floor is yours. Thank you.
Okay, thank you very much, Cesar. I would like to thank the organizers of this event for my invitation. I believe that this topic is very important, but everything goes from bilateral trade and all arbitrations. This goes as a part of and are based on the bilateral trade. So I would like to say a few words about our trade relationships between Russia and Brazil. We have something about 5.2 billion US dollars in our trade turnover. The recent years, we have a positive trade balance with Brazil. Russia exports more goods to Brazil than Brazil export to Russia. So Russian export to Brazil is about $3.6 billion, and Brazil export to Russia quantity about $1.6 billion of goods. So as you know, these numbers are from 2019. This year is will be a little bit moderated by the pandemic events and pandemic consequences, unfortunately for us. But as we noticed that Brazil is very strong in agricultural business, and the main products of Brazil export to Russia goes from agricultural sector. And we believe that these figures till the end of the year will maintain equal, or they will be a little bit lower. But we don't expect a drastic fall in our trade. So the main products that Brazil exports to Russia are agricultural products, meat, sugar, coffee, of course, metals and alloys, soybeans, and nuts. So Russia export to Brazil are mainly focused on fertilizers. About 65% of exports from Russia to Brazil are fertilizers. So these are the areas where arbitrations can appear. Say, we hope, and one of our missions is to minimize the risks for our exports. But nevertheless, these situations appear in our day-to-day life. So I believe that this topic is of great importance for our companies, and taking in account that today's trade is very complicated. There are Russian companies that buy products from Brazil and send them to China or to India, and I think these episodes will be of great importance, not only about Russia, but also about other members of BRICS countries. So thank you very much for your invitation once again. and I wish a very interesting event for all the participants, and I wish that they will find the solutions and the ways how to resolve their problems that unfortunately is a part of our everyday life. So thank you very much, and Cesar, I once again would like to pass the word to you. Thank you.
Thank you, Victor. That was very interesting and very important to hear from the Russian embassy and from your practical experience and how uh, Russian and Brazilian companies deal with these issues, and especially we will probably like to hear from you again later during this program about how they tackle the issues such as applicable law, venue, and where to arbitrate, right? Whether in Brazil, in Russia, in a neutral place. And all these things will certainly come up during our discussions today. And so I would like now to turn the floor to José Nantala, who is our moderator and the mind behind this initiative, and really the one who approached CIArb with this wonderful idea of using this platform to bring these specialists together. José Nantala is a founding member of BRICS, the study group of BRICS at the University of São Paulo, where he is doing his doctorate studies. He's a practitioner in an arbitrator based here in São Paulo, and he's also a member of the CIArb Brazil branch. So, José Nantala, the floor is yours, and I wish you all a very good webinar.
Well, good morning for those here in Brazil. Good afternoon for you in Russia. It's a big pleasure to be part of this amazing joint event. Are you listening to me well, at least the panelists? Because sometimes the connections are unstable.
It's good.
Great. Well, first of all, I am not the mind behind anything. I am just somebody trying to build bridges among us all. And Cesar is also part of the building of this wonderful event that we are presenting now. We are making it together, you all panelists and everybody that's participating from this event. We are building it together. It's a joint initiative, and that's the best part of being international lawyers or international practitioners, that we can engage joint initiatives just as this one. And I want to thank everybody to come in to join us in this event, all participants. And following the agenda here, we would start the main discussions of this panel with a brief introduction on BRICS by Professor Paulo Casella. Professor Paulo Casella is the chair professor of São Paulo University of International Law, Public International Law, São Paulo University. He is one of the first Brazilian researchers on BRICS in legal terms, in legal subjects. He has a book on BRICS, which is translated in 2 or 3 languages other than Portuguese. And he is really a devoted researcher with lots of articles and materials published on this subject as well. So I would like to invite Professor Paulo Casella to make his introduction remarks, and then we move on with the rest of the panelists. Professor Casella, can you hear us?
Yes, I can. Can you hear me?
Yes, of course. Please, the floor is yours, Professor. Thank you so much.
So ladies and gentlemen, good morning to Russian colleagues. Добрый вечер, добро пожаловать. Я рад, вы работаем вместе сегодня в этом семинаре. The opportunity to work on this topic of concerning the BRICS is notwithstanding the conditions of that foreclose the possibility of being viva voce together and working on the same room. But nevertheless, it is very important to keep things going and to move on. And in a matter like arbitration, it is very important to build personal ties. So we have to know each other. We have to be familiar with the legal setting of the other country and the issues that may turn up, like Viktor Sheremetyev just mentioned. That's a considerable part of arbitration between Brazil and Russia is reflecting the contents of trade. So getting to know each other and knowing who is on the other side helps build confidence and trust. And BRICS is an initiative that goes exactly along these lines. It is something which Rosanna Antala has already examined, arbitration in the BRICS countries, and it was an innovative research work he carried on and by himself. So he went to the different countries, he collected materials, he finished his master degree, and now, as mentioned, he is doing the sequence in the doctor degree in the matter of BRICS. BRICS is a very interesting initiative because it is a major change in the international scenery, and it is something which was started peacefully. So it is not a result of wars. It is an initiative that has been commenced by these countries, emphasizing that we need some changes. So BRICS works for reforms, including in the international financial institutions, International Monetary Fund, the World Bank. And it is interesting because BRICS in itself is not an international organization, but the BRICS countries have created an international organization. The New Development Bank is a concrete sign in the direction that the present features of the international financial system needs reframing, reforming, and improvements. And this is something which is very necessary for us to take into account among the 5 BRICS countries, and especially in the bilateral relations between Brazil and Russia. I am glad to have today the opportunity to share this event with colleagues from Russia and several colleagues and friends from Brazil also, because it is something which, differently from what happens with several other countries, in which in the University of São Paulo we have very frequent exchanges. It is something that when I organized a BRICS seminar in 2013 in São Paulo, we had 8 colleagues from the University of St. Petersburg and Moscow. And when we checked our files, it had been more than 20 years before that colleagues, professors from Russia had lectured in our law school. Since then, I have been 5 times to Russia, and we have welcomed colleagues from Russian, the State University of St. Petersburg and different universities of Moscow. And it is very important to go on building these bridges and building this communication. One of the aspects is that we have to go to a 3rd language to communicate between ourselves. And so something is already wrong in that way, that we have to, and the language is never a neutral tool. So it is something which okay, in arbitration, it's the lingua franca of our times, and we inevitably are glad to use English. But it was extremely interesting in a seminar in 2014 in St. Petersburg. The colleagues who organized it set up, instead of simultaneous translator, they will make it with subsequent translator. And the lady that made the translation was sitting with us around the table. And in several occasions during these 2.5 days of the seminar, when she had a doubt, how should I translate that into Russian or contrariwise in Portuguese? Then we turned up with a word in Latin. Both the Russian colleagues and the Brazilian colleagues turned, oh, that's ex contracto, ex delicto. Oh, I got it. We can move on. So, and it's interesting because we knew we had a common ground in that. And in case of doubt, it was Latin that helped us go on with the communication work and the exchange of views. And this is something which goes along the way in our seminar. So it is important to consider technical aspects, and arbitration is a topic that you need a legal framework, and the law that was enacted in Brazil in 1996 was a considerable advance in the position of Brazil in international arbitration, because before that we were only connected by the old Geneva Protocol. For a long time, Brazil was a weird exception in the arbitration world. We had not ratified for a long time the New York Convention on Arbitral Awards. So we only had the old Geneva Protocol of the 20s as an international act regulating arbitration from the Brazilian point of view. Since the enactment of the arbitration law in 1996, shortly thereafter, Brazil also ratified the New York Convention on Arbitration, and it is a practice that has entered the mind of legal practitioners and of the business operators. So this is a reality that has come to work and works very properly. I have had several occasions, opportunity to work as arbitrator, sometimes as expert witness, giving legal opinions on some aspects of Brazilian law, or as lawyer in different occasions in London, in Geneva, in Paris, and in other including in Lisbon and in Angola, in Rwanda, in arbitration procedures. And it is something which we have to count on due to the fact that there is an institutional overload of work in courts. And it is something which the reasonable length of a procedure is sometimes something that remains in the books. In practice, it can take a very long time to finish a judicial procedure. This is one additional reason for what arbitration should be located in the minds of the legal and business operators and should be inserted in agreements or referred to in case trouble or misunderstandings turn up during a business relationship. And you do not set up arbitration procedures with people you don't know. You have to know which are your partners, with whom you are doing business, with whom you are doing legal agreements, in order to set up an environment that is favorable to an efficient device for solution of the differences of controversies. And this is something which initiatives like today's can contribute to that. And we have to consider, and that's something which I cannot refrain from mentioning, that it was, we have to reinforce the private sector channels and the communication. The present condition of Brazilian government is a shame. For all that have witnessed the speech that was presented by Brazilian president yesterday, I'm sorry and I am ashamed for what was performed yesterday. There is full of lies. There is a lot of problems that are not being taken properly care of in the environmental issues, in the managing and the strategy against the pandemic, COVID pandemic. So this is something which we cannot rely just on the governments. We have to move on by our own means. And that's something which I do hope that all initiatives like today's will certainly contribute to further strengthen and develop. And this is an opportunity which I hope in a foreseeable future, hopefully before 3 or 4 years, we can do actual meetings along the line of this initiative today. So for all participants, it is very important that we keep things going. And again, thank you for being present. And BRICS is an initiative which I'm very glad to coordinate in the University of São Paulo. José Nantala and a group of researchers, we have published a book on legal aspects of BRICS that was ready and was distributed at the latest seminar in October last year. And we are on the way. It's in the printing process for a new book this year, which won't be delivered personally this year, but which will be able to reach to you in due course along the following months. So a good work session for us all, and compliments Zanatala for this another initiative you've figured out and carried on. So my thanks for all, and I'll be glad to go on participating in the discussions.
Well, thank you so much, Professor. It's always a pleasure to have you here and talk to us about those topics. Professor Casella mentioned the issues that we faced mostly in Brazil about international arbitration and the recognition of New York Convention and our arbitration law that passed in 1996, and the recognition of ratification of New York Convention that occurred just in 2001. It was really late. But what is really interesting about it is that Brazil, Russia, India, and China, they had almost common developments in terms of the development of arbitration in each of those countries. I'm putting aside South Africa because South Africa has a different development on this subject. But from 1993 to 1996, Brazil, Russia, India, and China enacted their arbitration laws, trying to internalize best practices worldwide witnesses. And Russia passed their first International Arbitration Act in 1993, and then Brazil did it in 1996. Both countries were trying to internationalize, were trying to be part of the international practice and trying to bring and attract investors. And arbitration was a big part of this movement. So this is why arbitration, development, commerce, free trade are always subjects that very close to each other. So making this brief bridge, building this brief bridge, I would like to pass the word now to Professor Nina Vilkova. Thank you, Professor. Professor Nina Vilkova is a professor of law at the Department of Private International Law of the Russian Foreign Trade Academy and chair of the ICC Russia Commission on Arbitration. So it is a great pleasure to have you with us, Professor Nina. It's a great honor for us to having you here. And please, the floor is yours for your presentation. Make yourself at home. Feel at home.
Thank you very much, Jose. It's a great pleasure for me to participate in this event. And really, this is the first important meeting with colleagues from different countries, from different continents, and plus in this COVID situation. Really, I think it's very important fact that you just mentioned, that Russian Federation and Brazil adopted law on arbitration in 93 and 96. And the most important thing, and international importance of these laws, we can find in the model law, ancestral model law, which was a base, both, I think, Russian Federation and Brazil legislation. But I would like to start with some small history of arbitration in Russia. Because, for example, Russia, before the revolution, arbitrations, третейские суды in Russian, existed in major regional business center. It was some center Archangelsk, Nizhny Novgorod, business cities on the river of Volga, and in the beginning of 20th century, in 1911, draft provisions on Chamber of Commerce and Industry in Russia were prepared. And in paragraph 12 of this section, competence of the chamber, it was provided that the chamber solved disputes arising out of the trade and industrial matters as arbitrators, if there is a valid agreement on this between the parties. And I think it's first legislation which clear underlines the importance of arbitration. It was not international arbitration at that time, it was domestic arbitration, but I think this fact is very important. As to the Soviet time, it's interesting to underline that in 1932, in accordance with the regulation of the government of the Soviet Union at that time, was created arbitration commission for foreign trade at the Chamber of Commerce of the country. It included 15 arbitrators, no one woman, and they were specialists in the foreign trade and foreign trade regulation. And the first award of this arbitration commission was given in 1933, and then the time passed, and in 1967, commission was changed, name of the commission was changed to Arbitration Court, and in 1993 into the International Commercial Arbitration Court, which function in nowadays. As to New Russia, very interesting two facts I would like to underline. First of all, law on international commercial arbitration 1993, which you already mentioned, and very interesting situation. That this law enacted a new rules on international commercial arbitration and maritime arbitration commission. This is two arbitration which have as a fundamentals for their activity, law on international commercial arbitration, because all other arbitrations existing now in Russian Federation, they were approved by the government of the Russian Federation, not by the law. As to New Russia, very important stage. It was adoption of the law on Tretейские суды, on arbitration in Russian Federation in 2015. It was a federal legislation, federal law, and this new law regulates the procedure of formation and activity of the arbitration centers, settling domestic and international disputes. And before this law in 2015, in Russian Federation existed more than 2,000 small Tretейские суды, small arbitration for domestic disputes, and it was not a favorable situation for business because different arbitrations had not qualified arbitrators, and the awards were very far from international principles, from the situation which existed at that time. And under this legislation, under this law on arbitration in Russia, only ICAC, International Arbitration Court, and Maritime Arbitration Commission were endorsed as arbitration centers, and because their legal status was confirmed by law in 1993. Other international arbitration center, there are two. For the moment in Russian Federation, it's an arbitration center at the Russian Union of Industrial and Entrepreneurs, and Russian Arbitration Center at the Russian Institute of Modern Arbitration. Four in our country. Is it good or not good? I would like to say that all these arbitration centers are opened their branches and divisions. For example, ICAC has opened for the moment 19 branches from Vladivostok to Kaliningrad, from St. Petersburg to Tyumen. And this gives the possibility to resolve domestic and international disputes under the rules of ICAC in these 19 branches. As to arbitration center at the Russian Union of Industrials and Entrepreneurs, they have opened 10 divisions. And the Russian Arbitration Center, the Russian Institute of Modern Arbitration, 3 territorial divisions throughout country, and 2 specialized divisions, nuclear division and agriculture, nuclear division and agriculture division. So thus we can see that not always for business. It is necessary to come to Moscow, and there are many possibilities to resolve their disputes, both domestic and international, through in our country. That's why it's very interesting to give you information about arbitrators in this arbitration center. For example, ICAC have in their list 302 arbitrators, and many arbitrators, more than 50, are foreigners. And I would, as a member of Presidium of ICAC, I would like to invite you, your arbitrators, to come to Moscow and to give your permission to include you in the list of arbitrators. And as to arbitration center at the Russian Union of Industrials and Entrepreneurs, they have 122 arbitrators. Among them, there is one foreign arbitrator. And at the Russian Arbitration Center, there are 100 arbitrators and no foreign arbitrators. So we can see that from the point of view of the possibility to invite foreign arbitrators, ICAC gives the best possibilities for claimants and respondents. And I think that it is necessary to say that all lists, both in ICAC and in other arbitration centers, are open, so the parties can nominate any arbitrator to whom they trust, and this arbitrator have the same powers than arbitrator from the list. And I would like now to say some words about the way of awareness of these centers, how they are developed, and how business can give the information about these centers, about arbitration in Russia. First of all, through arbitrators. Because these lists you can find them in the internet, and to choose an arbitrator who the party wish to nominate. Secondly, from publications. We have some magazines created especially for international or domestic arbitration. For example, the Chamber of Commerce and Industry of the Russian Federation published a magazine called Commercial Arbitration. Russian Arbitration Association published online journal Arbitration Rule. We have also such magazines as Arbitration, Newsletter of International Commercial Arbitration, and Legal Insight. So from these publications, everybody can see the development of the arbitration, current issues of the arbitrations, and can participate in the life of arbitration in our country. Last year, in 2019, legal magazine Legal Insight has conducted a survey on conditions of arbitration proceedings in Russia. It's for the first time such a survey was prepared, And as a result, Legal Insight conducted that the ICAC is a leading arbitration center in international arbitration. During this, for example, during 2019, ICAC arbitration solved 522 cases. And arbitrators from Arbitration Center as the Russian Union of Industrials and Entrepreneurs solved 302 cases. So this, I would say, this is a good figures because both centers are very important and they resolve disputes not only from sale of goods, but from other situations. And another important point concerning awareness of arbitration. This is publications of the awards of the ICAC. For the moment, ICAC has published much more than 20 such collections of arbitral awards, starting from years 15th and of the last century and up to now. One of the last and the biggest collection of the ICAC practice is a volume concerning practice for the year 2004-2016, which includes more than 104 cases. For cases, of course, subject to maintaining confidentiality. Third, next situation and next possibility to give information to it's activity of the Russian National Committee of the ICC Russia, and in Russia, Arbitration Commission in ICC Russia now includes 70 representatives from legal, domestic, and foreign firms. And Natalia and Konstantin and me, we also are members of the Arbitration Commission. Arbitration Commission holds conference, the near annual conference on the topic of Russia as a place of arbitration will be held on 5th November. The topic Russia as a place of arbitration is the current topic of the annual conference of ICC Russia. And if you have a possibility, maybe you will also could participate in this conference. I don't know, maybe it will be offline or online, but we are waiting for on this conference, President of ICC Court of Arbitration, Alexis Moore, and another possibility of ICC Russia, taking into account COVID situation, it's a different webinar. I think every month ICC Russia organized different webinars concerning banking financing, Incoterms 2002, digitalization of international trade, new rules of conduct settlement of disputes around the contracts with guarantees, letters of credit, practical issues of construction, arbitration, banking support in international trade. So it's a very good possibility for disseminate information on the international arbitration in ICC, first of all, in all the world, and very many people participate in this webinars. So next possibility to to know arbitration in Russia, it's a possibility through universities. Not many universities in Russia propose students the special discipline arbitration, international arbitration, and so on. Only students on Russian Foreign Trade Academy, High School of Economics, and GIMO University are often courses on special courses on international arbitration. And other universities propose some information in the course, in the discipline private international law, but from my point of view, it's not enough for the moment, because students, young people, needs information on contemporary possibilities to resolve disputes, not only through courts of common jurisdiction. Next possibility, it's rather new in our country, this moot court competition, student moot competition on international arbitration. Russian Academy of Foreign Trade, my initiative, was organized in 2014 moot court competition on international arbitration, and in October next month, the 7th moot court will be held in Russian and in English, and it would be online competition, and next competition, I don't know, online or offline, would be in March 2021, and maybe your students would be interesting, and we invite them to participate in this moot court, because it's only one moot court which has two sections, Russian and English section. And I will very glad and that Natalia and Konstantin are also arbitrators in our moot court, and hope it will pass very good. And another good possibility, it's online arbitration. It's a very convenient format of the arbitration hearings, not only for this moment, the COVID situation, but in general, because it's efficient, it's modern, it's quite convenient both for international foreign arbitrators, for foreign participants of the arbitration proceedings. And I think it would be interesting to continue this practice, because, for example, for ICAC, for other arbitration centers in Russia, it was the first experience when there's no possibility to move and there is no possibility to organize offline hearings, and online hearings proved the utility, and it was for now it's very important and very useful in our country, and as well as in other countries, CIS countries. So I think I tried to present the situation in Russian Federation with arbitrations, international arbitration, and with the possibility of the awareness of this kind of dispute resolution in our country and abroad. Thank you very much for your attention. And I'm ready to give answers to your questions if you have them. Thank you.
Professor Nina, thank you so much for your words. It was really amazing. You covered all subjects that we wanted to discuss here, as our flyer indicates. We covered here opportunities for young practitioners with the moods and all the discussions that you have there in Russia, the developments of the recent developments in arbitration in Russia on the institutions, all the institutional panel that you brought to us with all news and branches that are working from this day, and online arbitration, so technology. Thank you so much. It was really, really interesting, this great framework of international arbitration and arbitration itself, even domestic arbitration in Russia. Thank you so much. It was very enlightening.
Thank you.
And I would like to pass the word now, the floor to Professor Nadia. Nadia is a full professor of international law at Pontifical Catholic University of Rio de Janeiro here in Brazil. She's also an arbitrator, a lawyer with great practice here in international arbitration as well, and one of the most important international private law professors here. I am a big fan also of Professor Nadia. Every time she launches a book, I'm buying it and asking for a signature. Thank you so much, Professor Nadia, for our participation. The floor is yours. Make yourself comfortable.
Thank you. It's a pleasure to be in this webinar. In Brazil, we are in the morning, in Russia in the afternoon. That's so how international we are. And I thank Cesar Pereira and José Nantala and all CIArb for this invitation. I'm very glad to be here with my colleague, Professor Casella, colleague for many, many years, and all my Russian colleagues. Good morning from Brazil. I will start where Professor Nina Vilkova finished. She finished with the importance of live hearings in this new medium with technological means that we need to adjust and adapt, not only in this time, but from now on. I don't think we are going to be back to what we used to do. And I will share my, I prepare a very small presentation that may help viewers from other countries. And I want to touch upon three basic things in this very short presentation. I will just go lightly on some basic information on the Brazilian system of international arbitration, because it helps mutual understandings between us and Russia. I will make some notes on the use of modern technology in international arbitration, and I would end up with some points that may affect international arbitration between Brazil and Russia, considering all these matters. Our system of arbitration has elected geographical criteria to determine whether an arbitration is local or international. So we are part of the New York Convention, as Professor Casella already stated, and our law says that if you have your seat in Brazil, you have a Brazilian arbitration. And if you have your seat elsewhere, you have an international arbitration. This has dear consequences to international arbitration, because when you are in the negotiating time of your clause and deciding on the seat of the arbitration between Brazil and Russia, if you decide that the seat would be Brazil, execution will be more direct, while if you decide that your seat will be in Russia or in a third country, you will need to go through an action of recognition and enforcement of the award before it can be executed in Brazil. So this is something to have in mind. And the procedure is called uma ação de homologação, which is a procedure of homologation at the Superior Court of Justice in Brazil. Thus, the choice of the seat of the arbitration is paramount to the future consequences of your arbitral award, and this has to be bear in mind in the BRICS arena. If you are in an international commercial arbitration with big other BRICS parties, the seat will be paramount to your execution of the award if this execution is in Brazil. Even though we are a member of the New York Convention, we still require this action in Brazil to be able to execute the award. Unless, of course, if the parties pay the price without any other type of means. But that's not the case. And we have seen that once you have an international award, you will need this action in the Superior Court. And there's a lot of fight over if you can do it or not. The good thing is the Superior Court of Justice has pretty much agreed to all awards that has been presented to them. Since they started, we had around 110 awards, and there was only around 8 to 10 that, because they were considered to be against public policy, they were not granted the execution process. Brazilian courts consistently show respect for party autonomy and best practice in arbitration. So this is really good news for an international arbitration in the BRICS setting. Going to my second and most important topic here, and that's what we want to talk about today, which is the use of modern technology in virtual hearings. Plan ahead. That's, I think it's on everybody's mind. There's no such thing as no planning for such a hearing. It is more complicated, it is different, and people have to be aware of new problems. Of course, a hearing in an international commercial arbitration is something that the parties, the lawyers, the arbitrators, and everybody involved plan carefully. But there's an added layer of planning if you have a virtual hearing. The tribunal always have the power to decide how the taking of evidence will take place, but it's good to look at certain guidelines that have been issued lately. One is the ICC Commission Report on Information Technology in International Arbitration. They have a very good guideline for that. Even if you do not use ICC as your chamber for arbitration, you can still use their experience and their rules. This is all soft law to prepare for your hearing. Another thing that is not so obvious that I would like to touch upon, and people who know me know how much I'm attached to the Hague Conference on Private International Law. The Hague Conference has a convention on taking of evidence, the 1970 Convention on Taking of Evidence, which is for judicial courts, which is for evidence in the international setting with courts. However, just this year, they finally finished a guide to good practice on the use of video link, mainly for witness testimonies for the evidence convention. The guide is online. It's very thoughtful. It is the result of the work of many years. I know there was an expert group working on this since 1914 at least, but it's amazing how it just came out during the pandemic. So it is there for everybody and it's very useful. Talking about careful preparation, a few points we should look upon. Privacy and security, the use of platforms as we are doing. it is very important to choose the platform and have a certain service. As we are having today, we do not have to deal with who is on, who's not on. CIArb's technicians are taking care of our conference, of putting it in YouTube and many small things like that. It's very important. The lawyers, the arbitrators, they're concentrated on the hearing. They need support for this technical phase. Also, because this support will help with security. If you can have live transcripts, how you would present your documents like I'm doing, sharing the screen, who will operate that, that's very important to have support. The witness testimony will certainly take longer, especially Russia and Brazil are civil law countries. We are used to a slower pace of taking evidence from witnesses. However, if you are in a setting with a common law lawyer that is used to cross-examining, that has this rapid pace, well, this is all gone with the online hearing, because you cannot speak over another person. You have to speak quietly. And you have to wait till the person finishes in order to start. So this rapid pace of questioning just don't work in a virtual situation. Rules of procedure concerning witnesses situated in other countries. The Hague guidelines has a lot of experience because you depend on the applicable law. You may be hearing somebody in Russia that has certain concerns, and here we have different ones. We have to think of all that before. If interpreters are needed, you have to plan carefully. It's not as easy to have simultaneous translations over a platform. How would that be? So this has to be thought in advance. A small note for lawyers. I've been hearing a lot, and I myself had a few experiences with all this internet and all this webinars, and it suits us also for an international hearing on arbitration. I heard somebody says we have to think now we're not on the stage, now we're on TV. And if you talk to actors that have both experiences as a theater actor or a TV actor, they tell you the difference that is. You have to prepare your settings. Is there any noise? Close the door, smile, look at the camera, focus, maintain eye contact, do not interrupt, much more breaks. Sometimes that's good. You can put just your photo and leave a little bit and come back, which in a present type of hearing you cannot do. Advanced training, and especially how you communicate with your team. If you have breakout rooms or not, if you have a certain way of talking to them. Would that be through WhatsApp? Would you be in the same room as your team? Although we're doing social distancing, 2 or 3 people can be together. Should the team be in one place or not? And certainly speak more slowly, because sometimes there's a small delay in all this communication. So these are tips I've been getting here and there, and although they're not so juridical, they do impact how you present yourself and how your hearing is going to be. And I would like to add this type of analysis, the SWOT analysis, to arbitration that I've seen the Swiss Arbitration Association do, and I thought it's something for us to think for the future. Well, what is all the use of technology in virtual hearings will bring us for the future? What are the points we have to think about? And the SWOT analysis divides between strength and weaknesses, opportunity and threats, and some are internal and some are external. And I think for us, of course, it is a strength to have less traveling, to be able to better schedule. In international arbitration today, if you have a hearing in one country and teams from parties, experts, and witnesses have to travel, it is a lot of planning. It is very expensive to have all the team for a few days in another country. And with the virtual hearing, we eliminate this cost. And the agendas can be put together easier, in an easier way. On the other hand, there's a weakness, the technical risks. If the internet doesn't work, if you're out, and all these personal interactions that we have with the court, the eye contact, the things we perceive when we are in the presence of the arbitrators, and to get their attention if you're a lawyer, and as an arbitrator to be able to see how the lawyers move, to be able to see how the witness is reacting. All this, there's a loss here in a virtual situation, scenario. And we have an opportunity for cost and time saving. Russia and Brazil are far apart. It's not easy to go here and there. It's very costly to have an international arbitration with parties from both countries. So cost saving and time saving in a virtual hearing is positive. Also, you can work more with an international team. Probably one of the parties, even though Brazil and Russia, depending on the case, you need lawyers from other countries as well. So this is space for opportunity. There's a threat. The big thing from outside is the use of this new technology, the online hearing, and all the aspects of the security and of tampering with the witness if the witness is not prepared, or if it's being coached by somebody else. Is she alone in the room, he or she? These are preoccupations that it's a threat, and the use of the technology doesn't help us much. At least we think it doesn't, because we were used to the other way around. But more and more, we know that everybody's in contact all the time. So this is a good scenario. And I would like to finish with a few points that I believe are specific of arbitrations between Brazil and Russia. First of all, time zone issues. It seems silly. We're in an international arbitration case, complex, maybe a construction with experts, with lots of documents, difficult questions, but in fact, it is not easy to plan if you're not in the same place, the time schedule. So to achieve a good balance, you have to plan ahead. Maybe we cannot have full days of virtual hearings. Maybe we can only meet for 3 or 4 hours so that it's not too early or too late in each country. I've talked about that already, but there is a challenge with the translator, the translation in virtual hearing, the simultaneous translations not possible in the way we are used to, and that's difficult. Applicable law, an issue, very keen to private international law, but I believe we won't have that much problem there because we follow the civil law tradition. Unless I'm wrong, my colleagues in Russia can maybe, when we're discussing this, tell me if I'm assuming too much, but more written submissions may help bridge that gap. And the hearing should be simpler, should be smaller. Also, for the future, my last note, a hybrid format. I don't believe we'll ever go back to all present. We will add to our lives something in the virtual arena. It may be that in the future, we prefer to go back to a hearing with everybody present, but there's one witness that is in another country. And then instead of flying them in, we'll hear them online. So I don't know what the future holds, but I believe that what happened to us and the way we adapted in 6 months are here to stay. And the final thing is the challenge of the applicable law. Where's the seat of the hearing? This must be decided by the tribunal in advance. This has dear consequences to all procedural issues, even though in arbitration, procedural issues are not from a specific country, but for emergencies, the seat of the arbitration is very important. With that, I finish. I thank everybody and I stop my presentation.
Thank you so much, Professor Nadia. It was really amazing how you touched all those bases, all those topics. They are very important, especially nowadays when we are facing all those challenges on pandemics, and our practice is deeply affected, and we've been trying to adapt ourselves to those new features that in domestic or international practice are very important for us in the present day and also in the future. I would like to move on with the discussions. We have here our discussants from Russia and Brazil. I'll start with Natalia Guliaeva. Natalia, she is a partner of Hogan Lovells there in Moscow, and she is a fellow of the CIArb. So she is part of CIArb as well, and it's very good. She helped us. She is co-responsible for this event with Mr. Konstantin as well. Konstantin is a partner of Denton's, international arbitrator, just as Natalia, with great experience in international arbitration as a whole, with practice also in London and UK. So it's always a pleasure to talk to you and to check and to see what are your thoughts and your comments on those topics. Carolina Morandi is the Secretary General for the American Chamber of Commerce here in Brazil, AmCham. And she has an LLM in Stockholm University. So she's also used to some issues related to Russian parties and arbitration with the Russian parties because she had an experience in Stockholm. Stockholm is it's a known venue for arbitration in Russia, as we are mostly knowledge about. So we have a team that is very capable of bringing good discussions to our participants, to our panelists as well. So who would like to start making comments? Natalia?
I'll be very happy to start. And bom dia, Brazil. I have been to many places in Brazil. I was about 7 times in your country. And I visited Natal, Recife, Búzios, Rio, Sao Paulo, Manaus, Cuiabá, Salvador, Brasilia. So a lot of places. Lovely country, wonderful people, very good food, very good food. I must just say, my first time in Churrascaria was incredible. So everything is very nice. So, and I think just for us to, since this is a CIArb webinar, I would like to put the first question to both Nadia and Nina, because I would like to know what has attracted you as practitioners, as arbitration practitioners, to the Chartered Institute of Arbitration, of Arbitrators. Why CIArb is important for Russia and Brazil-based practitioners? Could you perhaps comment on that? It's very interesting.
Who starts, Nina or Nadia? Nina, could you start?
You both are on mute, yeah.
She's on mute.
You're muted, Nina, please. Let me try to unmute her. No, I can't.
No.
Так, нажмите Alt, чтобы включить. Так, включить. Now, it's okay now? Thank you. Thank you. I'm a member of CIArb for many years. I think it was the first time when this organization invited Russian specialists to CIArb. It's a very important possibility for every practitioner to get acquaintance with the best practices of international arbitration. It's a good possibility to know techniques, to get acquaintance with the publications, which are important for not only for arbitration, but also for law, for contract law, because the recommendation of the CIArb concerns sale of goods, concerns other things, other contracts, I would say. Then there are many publications and many possibilities to get acquaintance with recommendations. Plus law journal and resolver. These publications reflect the main directions of international arbitration. And taking into account that Russia and Brazil are civil law countries, but sometimes we resolve as an arbitrators disputes with under English law, or for example Indian law, which is very close to English law. It's very important to know how English law, common law, English law can implement in arbitration. It's very interesting to get acquaintance with the testimonials, with the different kind of receiving information, not only from свидетелей, but also from claimant and respondent. Why so? As we address the Russian treaties case, so the Russian domestic arbitration, many disputes are not very difficult, and there is no possibility to have a plan for arbitration. Is not with no possibility to call conference and so on, because there is a small contract. One party has made everything under the contract, for example, sell the goods, deliver the goods, but other party not paid completely for this goods. So it's not very complicated. And domestic disputes, it's a disputes under Russian law, under Russian civil code. Also, not many problems because it's our legislation, and we have the possibility to open the book, to see commentaries, to see different legal position of the Supreme Court of Russian Federation, and so on. And just another situation when you arbitrate, when you participate in the arbitration under common law. It's very interesting for me to have some possibilities, not only in Moscow in ICAC, but also in LCIA, to participate as an arbitrator. And it's amazing, frankly speaking, because it's a very, very net plan. It's a very good organization of the procedure. And for me, as for arbitrators, it was a very good school because now, for example, in ICAC, there are very many complicated cases. And this experience, this recommendation of CIArb helps, very much help to arbitrator. So I think it's just a good explication why, first of all, CIArb is interesting as an arbitration center. And I think it's a very good possibility now to open a Russian branch of CIArb, and I would say many thanks to my colleagues, Konstantin, Nadalia, and other colleagues for this possibility to participate not only in CIArb, but also in the Russian branch. Thank you.
Nadia?
I think CIArb is a fine institution, which I was not that familiar with a few years ago. I'm new in the CIArb friendship, but the fact that there are a good liaison with many countries and what they do with their charter arbitrators, the fact that they have the course and the exam and all that, it gives you a certain guarantee of quality. So, but and these guidelines, I think today all arbitrators are aware of how much soft law is important for us to move on. And most of these institutions like CIArb or ICC have issued guidelines, and I'm always seeing all these guidelines and seeing which one adapts better for the need of a certain arbitration. Acting as an arbitrator, I have this afternoon, probably I have a conference call to decide whether there will be a virtual hearing. The party's not so keen. In any way, all this soft law helps us prepare, helps us decide which is the best way, because for the moment it's just impossible to have hearings with everybody present.
This is very insightful, and thank you very much for your answers. And we have one specific question, Konstantin.
Thank you, Natalia. I think that Natalia was going to say that we have a specific question to Professor Vilkova, to Nina. So if I'm asked that question, in your very insightful presentation, Nina, you mentioned that in Russia we used to have about 2,000 small arbitration institutions, and after the arbitration, and which is certainly unusual if compared to other jurisdictions. And after a major arbitration reform that we had, the situation is now totally different, and we we now have only few arbitration institutions. So do you think that we are now where we would like to be, that this is the optimum size and scope, or do you envisage further developments in this field, and do you expect that there will be more? Well, hopefully not 2000, but do you expect that we will see more arbitration in institutions? And also in that connection, I think interestingly, it is possible for foreign arbitration institutions to be sort of recognized and licensed or approved by the Russian Ministry of Justice. And there are currently two foreign institutions, the Vienna International Arbitration Center and Hong Kong International Arbitration Center, that are sort of recognized and acknowledged by the Russian Ministry of Justice. And do you expect that there will be further foreign institutions joining? Thank you very much.
It's a very good question because both questions are important, I think, because, for example, how many arbitrations do you have in Brazil? For example, in Ukraine, there is only one ICAC which resolves disputes from international contracts. As to domestic domestic contracts, there are some I don't know the figure, but there are different arbitrations, domestic arbitrations. So what is the situation in your country? How many arbitration centers, arbitration courts resolve disputes from international contracts? Many? Or one? Or 10?
We have a few, if I may answer that.
Mm-hmm.
I think we have CANCE, CBC, CIArb, CBMA. I think we have maybe around 8 to 10. Carolina will probably be more the right person to answer that. But it's a small number of good and reliable chambers.
Mm-hmm.
There was an effort in Brazil by people that wanted to put up like an arbitral tribunal and open up not reliable arbitral tribunals, and this was disbanded by the police. So this is not a problem anymore. So the good chambers are not in a very big number, but I would like Carolina to complete that information.
Thank you very much, Nadia. I'm sorry, Carolina. May you continue? Or you
First time speaking, so I would like to thank you for the invitation and congratulate you all on your presentations. It was very good. Thank you very much. He has opened an office in São Paulo a few years ago. We have in São Paulo, which we jointly organized an initiative a couple of years ago, doing arbitration in São Paulo in order to promote arbitral institutions in Brazil and São Paulo as a seat of arbitration. And in Rio, where Nadia is located, we have CBMA, which is also very strong. I think that these are the main institutions that come to my mind.
Thank you very much. I think we all consider that domestic it's one situation. And as Konstantin says, in our country existed more than 2,000 or maybe 4,000 domestic arbitrations. Sometimes they are reliable, arbitration, sometimes not. But there is no control. There was no control. There was no information on this arbitration courts. Plus, I don't know how this is the situation in your country, but in our country there were many arbitration courts at the big enterprises. Gazprom, Lukoil, Sberbank, and so on and so on. It's just the continuation of the Soviet tradition to have arbitrations, not третейские суды, at the ministries, at the different ministries of industry. At the Soviet time, every ministry has his own arbitration. It was a state arbitration, but nevertheless, after in New Russia and after the adoption of the law on третейские суды, on arbitration, we had very many arbitrations, but not always of the good quality, because you've said, Nadia, that there are arbitrations at the Chamber of Commerce. In Russian Federation, we also have more than 140 Chamber of Commerce all over the world, all over the country. And many of this Chamber of Commerce, before the reform, had their own третейские суды, their own arbitrations. For example, arbitration at the Chamber of Commerce in Voronezh, in the south of the country. They have no practice. They have no cases. Chairman of this arbitration court said me that no. After the reform, the situation has changed. From one point of view, Konstantin says, you must receive now license from the Ministry of Justice. But to receive this license, it's necessary to prove the Commission on Arbitration Development in the possibilities to conduct arbitration on the contemporary level. And another small point, before the reform, many domestic arbitrations existed, not at the Chamber of Commerce, but they were organized by everyone, by different associations, by advocates, and so on. So there is no possibility to find practice, to know who are arbitrators. There were many awards which not respond to law, and so on and so on. It was a situation. Now, yes, we have, for the moment, 4 Russian Center for Arbitration, and as Konstantin says, VIAC, Hong Kong courts of arbitration have the right to conduct the arbitration in Russia. Maybe it would be interesting for you that the first foreign arbitrations who after reform submit their documents to Ministry of Justice was the arbitration from Kazakhstan, not from Europe or from China, and so on. So they have not received the permission, but this fact existed. Now I would say that 4 arbitration centers is not enough for our country. But we have very many branches of ICAC in St. Petersburg, in Yekaterinburg, in Vladivostok, in cities with the big industry, with big possibilities and needs for arbitration. And there is also one detail, maybe it would be interesting for you. Many big enterprises like Gazprom, like other big enterprises, they have their штаб-квартиры, their offices, main offices in Moscow. And other enterprises, their enterprises who work all over the country, they have no right to sign contracts. They have no right to go to arbitration, to submit the claims to arbitration. Everything is made in Moscow. It's also one of the reasons why we have known for the moment more arbitration courts, because for international arbitration, for example, arbitration in Novosibirsk, in Vladivostok, it may be not good because there is no good arbitrators. It's the main problem. I've said in my presentation there are only 4 main universities in our country made enough information on international arbitration to students. So you can imagine that domestic arbitration is good, but for international arbitration it's not enough. So maybe this is one of the reasons why we have only 4 arbitration centers in Russia. Now we would have new commission on development of arbitration at the Ministry of Justice, and let's see what we shall have, because development of international arbitration, it's a very important thing for Russia, and I hope it will be developed, as Konstantin says. Thank you.
Thank you so much, Professor Vilkova, for such a comprehensive answer. I have many more questions, but being mindful of time, I think Natalia has a very important question on diversity, which is probably some of the most important questions of our discussion today. So, Natalia, please.
Of course.
Yes, the question is, Nadia and Nina, you are truly, well-known, distinguished practitioners, but simultaneously charming and dynamic women. And I think the audience has appreciated your speeches and appreciated you, first of all. And my question, in the interest of Carolina, myself, and the female audience, is to understand how did you accomplish all what you did, and whether being a woman was a competitive benefit, or it made sometimes things more complicated for you on your way to the fame. And just friendly advice to the audience and to us with Carolina.
Nadia, maybe you will start?
Okay, I'll start because it's a very hard question. I'm more and more conscious of this gender gap. I started early in private international law in a time, but at least Brazil was so close that nobody cared of private international law. So I was kind of alone. Nobody cared if I was a woman or not. And I followed through, and it happens that I had my credentials early on, and that helped. But I do feel that I'm involved in a lot of initiatives like Arbitral Women, and we have a group of women lawyers. And now with all the webinars, every time there's a webinar just with men, we call the organization, we make them hell. We are very active and very conscious that you have to give women their spot, because we're half, just that. Why should we be half everywhere? And I see students, they start at the same time, and I see men sometimes progressing and women progressing up to a certain point. And then there's the glass ceiling, the difficulties, the family. And unfortunately, in this pandemic times, there's a lot more burden upon a woman in the house than it should be. I don't see a very clear division of work in the pandemic with the kids, with everything. My kid is older now. I don't have this problem, so I'm in a very comfortable position. But I see my younger colleagues with a lot more responsibilities, and it's not easy to go ahead. So, but my advice to you all are just keep on doing it and ask for help for your colleagues and bond more with women. And I think we should give more. We should refer more to women than to men sometimes. And if there's a chance to choose an arbitrator, you should always have also a woman on the list, because we always have these names. We have enough names for everything. So we should not let pass an opportunity to also nominate, speak of, and send the name of a woman. And in this very sad week where Ruth Bader Ginsburg died, and after all she did, I think we're very well.
Thank you, Nadia. I would say that you're absolutely right, because to be a woman, it's a difficult task, because you have children, you have men, you have your work, and it's necessary to divide your time and your heart between them. It's not a good and not a small task. It's very difficult. So, and as to me personally, I've started my work after Moscow University at the Ministry of Foreign Trade, which does not exist now. And I worked at the legal department of the ministry, and it was a very good possibility to get in touch in those problematics of foreign trade. It was early Soviet time. There is no than 55 foreign organizations, and that's all. And for the ICAC existed at that time, resolved dispute between these foreign trade organizations and foreign firms. It's a very interesting practice. If it's possible to read awards of the ICAC, it was very interesting. Then. After my postgraduate courses, I began to be a professor of law, and all my life is connected with International Arbitration Court at the Chamber of Commerce of Russian Federation. First step to profession, it was a step of reporter or secretary of the arbitration tribunal. Then I began arbitrator, and now I'm also member of the board of ICAC, and it's a very interesting, I think, possibility to resolve disputes, to participate in the resolving disputes. It's amazing, I think. As to my experience as a member of ICC Court of Arbitration, I began a member of this court at the early 2000. And for the first 5 or 6 years, it was very many, a very small quantity of women as members of ICC Court of Arbitration. Then this quantity was grown, but my first impression was no woman. But now the situation has changed, and if you read a list of members of the courts, we will see very many women. And for example, chairman of the Arbitration Commission of the ICC, also a woman. So the situation has changed. As to destiny on Russian arbitrator, Russian woman as an arbitrator. The situation also changed rather quickly. And for example, for this, I mentioned that the first list of arbitrators in 1932 consists 15 arbitrators and no one woman. Now in ICAC, we have 32% women from different countries, from, for example, Norway, from Austria, from China, from China we have a man. So 32%, it's, I think, good figure. And as to arbitration center at the Russian Union of Industrials and Entrepreneurs, it's 40% women. And Russian Arbitration Center, 46%. So it's a good, very good. But you can take into account that ICAC deals with international disputes and two other arbitration centers, mostly with domestic disputes. And why these figures in two arbitration center are rather high, 40% in Russian Union of Industrials and Entrepreneurs and 47% in the Russian Arbitration Center. It's due to the possibility for state judges to continue the work as an arbitrator after they're retired. So the party of women in arbitration centers, in these two arbitration centers, are judges retired. There are judges retired. So maybe for this for another situation, we have not bad quantity of women in arbitration center. But what we need and what would be good to organize in Russia. I'm a member of ICC Women Commission, but unfortunately we have no Women Commission in our country. I hope that it will be in some years, near future, but I think it would be a very good possibility for women lawyers, which are many in our country, to enter to arbitration society. It would be very good. So thank you for your question.
Thank you, Nina. Thank you so much. Carolina, I think you have comments on diversity, which is a subject that you deal with every day. Please make your comments here.
Yes, thank you, Natalia, for bringing diversity on the table for us to discuss. I will because I will need to leave as soon as I finished speaking here, because I need to be in a meeting with Sweden. So one of the bright sides about modern technology is that we can be at the same place, different place at the same time. And that's my case now. So I have to start apologizing. But I couldn't help to notice and to be thankful for the opportunity of speaking at an event where the two keynote speakers were women. That's something I appreciate and I value. I try to implement at AmCham, and it makes me very happy. And half of the speakers here today, all the panelists, are also women. Nadia mentioned the United States Supreme Court Justice Ruth Bader Ginsburg. And one of my favorite quotes of hers is that when she said that women belong in all places where decisions are being made. This applies certainly to arbitration, and that's an effort that I believe that we all, the stakeholders should apply. Arbitral institutions, arbitrators when appointing the chair or presiding arbitrator, parties, companies and lawyers. So I think it's a common effort. I would like to share with you some numbers. I always think that numbers are interesting to listen. And at AmCham, we annually organize an international arbitration conference, and we have this online survey system. So every attendee has like a remote control and votes while watching the sessions. And I once asked the panelists, it was more than 200 people, have you ever appointed a woman as an arbitrator? And 44% said yes. Well, it's near 50, it should be fine. But if we consider that a tribunal is usually composed of 3 arbitrators, should be more than 44%, but that's okay. Then I asked, have you ever had a dispute settled by 3 male arbitrators? And 90% said yes. And then I asked, have you ever had a dispute decided by 3 female arbitrators? And 94% said no, only 6% said yes. So that's something that we should keep in mind. Why are we used to seeing 3 male arbitrators deciding on a case, but not 3 female arbitrators? At AmCham, it comes to my mind 2 proceedings where we had 3 female arbitrators, but out of how many? So that's something that I think we should keep in mind. But it makes me happy to see that in 2018 and 2019, the appointment of arbitrators at AmCham, nearly 60 to 63% of the arbitrators were men, and 40 to 38% were women. So I think we're talking about an increase of gender equality. And just to sum up and to leave the floor to the other discussants, I think that as a woman, I love talking about gender equality, but there are also other aspects of diversity that we should not forget. We talk about age, we talk about ethnicity, we talk about geographical diversity, and I think that's we should not forget. Jay-Z's case last year when he criticized the AAA system, that they only had 2 or 3 arbitrators out of 200 that were African-American representatives, I think brought up to light the ethnicity in arbitration, and we should not forget. So I just wanted to make this quick comments. I apologize for leaving, and I would like to thank you all again for the invitation and for the lessons, many lessons learned from you all.
Well, I would like to thank everybody. We are really just arriving at the end of our time limit here, but I don't know, maybe if we could have some closing remarks from Nina and Nadia, Victor. In advance, I would like to thank the CIArb for the organization of this panel. It was really amazing. I would like to thank everybody to join in and to make part of this. Let's hope that we have the other episodes of the BRICS, arbitration BRICS. And I don't know, Nadia, would you like to start?
Yes.
Just closing remarks.
Just thanking everybody. It was a pleasure to meet Nina and be with the others that I know already, and dear friend Paulo as well. It's a pleasure. I just want to stand at that and finish.
Great. Nina?
I would also say many thanks for, first of all, organization, this first episode, and I hope we'll have second, third, and other episodes of arbitration in BRICS countries, and especially in Russia and Brazil. I also visited your country one time. It was many years ago, and it was a meeting. It was a conference of the Federation of Women Lawyers. This federation was established by French women lawyers in 1928, and we also participate in this conference, which took place in Brazil, and it was also amazing. It was in Sao Paulo, and I have many memoirs from this meeting with my colleagues. So I wish you many good things. Be safe, and hope to have another possibilities to meet and to continue discussions on international arbitration. Thank you.
Oh, Victor, do you want to say anything?
Yeah, maybe I would like to thank once again for this invitation. Very interesting event. A lot of professional opinions we've learned today. So I believe that this event will be very helpful for our companies that are dealing with international trade, international projects, and you are always welcome. If any assistance is required from Russian Trade Mission in Brazil, please, there are our contacts on the internet, and you are always welcome. Thank you very much.
Well, I would like to thank everybody. Sorry, we are already 2 minutes in advance of our time, but I will talk to the panelists to answer. We have 2 questions that were unanswered here in this event, but we will try to reach the participants and answer them in writing. We're sorry that we could not discuss this here online with you, but that happens in events like this sometimes. Well, thanks everybody once more. I hope to see you all in presence in the near future. Thank you, Professor Casella, Natalia, Constantine. Thank you, Cesar, Victor, Nadia, Nina, and Carolina, and everybody that participated with us from this amazing event. Thank you. Bye-bye.
Thank you, colleagues. Thank you. Bye.
Bye-bye. Thank you.